happening for the state. So there was a direction upon the state as well as the WBSC to file a report. But we need time.
State and who is representing?
I'm to the WBSC.
Your report?
We have not received the report.
You have not received instruction or
Earlier we had filed our opposition.
opposition has been filed?
Thereafter there is a direction for
Yes.
joint inspection and file a report. Can you see the last order?
11th March order.
11th. You have conducted the joint inspection.
Worship, that instruction is not seen. Whether the inspection was done or not.
Learned advocate, yes. Learned
No, I'm the
advocate, this matter is
petitioner.
appearing under the heading to be mentioned. Learned advocate for the state and the WBACTCL seeks accommodation to file report in terms of order dated 11th March 2025.
My lord, kindly record my submission.
Yes, what is your submission?
My point is that an order dated 9th January 25, which is very similar to 11th March 25,
9 January,
9th January 25.
just a minute. 9 January.
The Honorable Court has directed the state to file a report regarding the inspection of the plots.
Process, okay.
A similar order on 11th March 25.
Mr.
It's a quite long time.
Kumar Ray, learned petitioner in person, submits that repeatedly orders have been passed to ascertain whether notice of joint inspection was actually served upon the petitioner or not. The state and the respondent WBACTCL were directed to file respective reports in this regard. However, despite such directions, reports have not been filed as yet. Therefore, one of the submission to 6. Let's search. Take a cover question.
It has a instruction given to the
Reports be filed within a week from this date. Advance copy of the report be served upon the petitioner, exception if any be filed within a week therefore. Upon expiry of the aforementioned period, liberty is granted to the petitioner parties to mention. You find out from your department what is the report Repeatedly, there has been a plea that the joint inspection has been undertaken without there being any
My
notice.
contention is that, my lord, if it continues, then it would be an abuse of the process. Because 1 year has passed. This is my contention.
Liberty is granted to the parties to mention after expiry of the aforementioned period. Give an advance copy of such report to the petitioner. In. This matter is appearing under the heading to be mentioned. Inadvertent typographical error has crept into order dated 10th June 2023 at 2026.
Last.
It will be Kuchbihar
Yes.
in paragraph number 9. In line number 2, mentioning the words District Inspector of Schools AC Jalpaiguri instead of District Inspector of Schools AC Kuchbihar. The words in paragraph number 9 in at page 4, paragraph 9, line number 2, our second line. Be read as District Inspector of Schools AC Kuchbihar instead of District Inspector of Schools AC Jalpaiguri. The order is, aforesaid order is modified to the above extent. The remaining portion of the order shall remain unaltered. This order shall form part of order dated 10 June 2026.
Item 3.
Item 3, Lordship, I'm for the petitioner. Lordship, this matter is pertaining to the overdrawal. My lord, the petitioner has already deposited the amount, Lordship. It's in paragraph number 10. Lordship, petitioner was an assistant teacher of a Lolegaon primary school, Lordship, and he retired. Yes, Lordship. Lordship, this is a matter pertaining to overdraw, Lordship.
23. Deposited
Yes,
on
Lordship. It's deposited on 4th of 7, 2024.
4th July.
4th July of 2024, Lordship. It's mentioned in paragraph 10, Lordship. As well as in the cause list, in the list of date. We have already served to the other side, Lordship.
Order to deposit was passed on which date?
Ordered of said amount. Lordship, it's in 2025 for pension payment order.
May 25. July 24.
It's in the list of date and paragraph number 9 also, Lordship.
This is a pension guarantee. You have refunded or it has been deducted?
So, Lordship, return been deducted.
Deducted? It is deducted or refunded?
No, we refunded, Lordship.
Refunded?
Yes.
So why did you write in para 8 that it has been deducted?
Lordship, kindly give me a second, Lordship.
The pension payment order does not show that it has been deducted.
No, Lordship, it's
See, in para 8 you say that
yes, Lordship.
the deducted amount is a part of gratuity
The
amount.
amount, yes, Lordship.
This is a wrong statement.
Lordship.
Yes, Mr. Ghosh.
Particular kindly comes up, page number 9, the fair portion says that this was the interest amount for the delayed payment of that.
In prayer.
This is the fair of them. Without overdrawn.
It's
No,
an
repay.
overdrawn.
Page 16, repay the overdrawn amount.
Yes, to repay the alleged overdrawn. It's in the paragraph E.
16.
Page 16.
It is not there. 13.
It's not there in our.
13.
To take my
The
pen.
PPM is there, apart from that,
No, this is writ petition WPA 813. Lal Bahadur Chetri.
813.
Jalpaiguri क्षेत्र की तो कम रहते हैं।
three.
813.
813. Dal Bahadur Chetri.
They have written it as 838.
No, what is the petition? Petition.
Yes, petition name.
838 madam.
838, no, 813.
The copy has been submitted 838.
Petition.
Petition name madam.
Name.
838.
Lordship, then it's probably the
Maybe
mistake,
838.
clerical mistake, Lordship.
Oh. এটা আলাদা তাহলে 813 there is another writ petition 813
আলাদা
oh 813 you have not been served
No, it's served, Lordship. We have to service. Service.
আচ্ছা না
हाँ बने तो है कि इनको दुटो नंबर तो आलादा तो सेम अभी हाँ ওটা interest on gratuity. This is on overdrawn.
তাহলে এটা একটু পাস ওভার অফ দিয়েছি না
হ্যাঁ Yes, you know. I have seen case.
what is your submission
Already they have deposited the chalan by your chalan, they have deposited the
Yes.
amount. And
you refund the amount
kindly come to the page number.
This month.
Page number 19, you know. Excel article.
It's
yeah. This is after retirement no?
after retirement.
After retirement Ashu, affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for the refund of the alleged overdrawn amount of rupees 43469 to the petitioner along with interest at the rate of 8% per annum from the what is the date of refund pay করতাম না? Interest from the date of retirement till the date of actual payment. The petitioner contains that he was an assistant teacher of Lole Gaon Primary School, Post Singji, District Darjeeling. The petitioner retired from service on superannuation on 30th November 2023. Since, the petitioner was not granted the pensionary benefits the petitioner was informed by the office of the concerned district inspector of schools that certain amount has been overdrawn due to wrong fixation. On such score, the petitioner was directed to deposit the alleged overdrawn amount. On 4th July 2024, the petitioner deposited the alleged overdrawn amount of rupees 43469 to the concerned treasury office. Upon deposit of the alleged overdrawn amount, pension payment order was issued on 20th May 2025. The petitioner not getting such direction of the concerned district inspector of schools is to refund the amount is refund the alleged overdrawn amount is impermissible in law. Hence this writ petition. Abhi submission the same Rafiq Masi. Upon hearing the learned advocate, Mr. Orijit Ghosh, learned advocate representing the state respondents, owner submission the same of Rafiq Masi did. Submits that the petitioner has deposited the alleged overdrawn amount without any demur, and as such cannot claim for refund of the same. He seeks for dismissal of the writ petition. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the direction of the concerned respondent number district inspector of schools is
Respondent number 4, Lordship.
4th district inspector of schools P Darjeeling for a refund of the alleged overdrawn amount is sustainable or not. In order to examine the aforesaid issue, it will be apposite to reproduce paragraph number 18 of the decision of Honorable Supreme Court in Rafiq Masi Sutra 18. Bearing in mind the aforesaid observation of the Honorable Supreme Court, since it is found that the petitioner was directed to deposit the same after his superannuation on 30th November 2023, and the deposit has been made on 4th July 2024. Hence, such direction to deposit the alleged overdrawn amount is impermissible in law. Accordingly, such and such is directed to refund the amount together with interest at the rate of 8% per annum from the date of refund till the date of actual payment. Within a period of 6 weeks from date of communication of this or this
Grateful
post.
Lordship. For Lordship and for the petitioner, Lordship. This is on gratuity and arrears matter pertaining to gratuity and arrear, Lordship.
Arrear.
Yes, Lordship. Service, gratuity and arrears. Pension.
The petitioner himself.
Service as single BPO.
State.
Yes.
When did you retire?
He's been retired, Lordship, in 31st May of 2024, Lordship. It's in paragraph number
PPO
2,
issued on
Lordship.
20th February 2025. Amount received
18th of March 2025, Lordship.
18th March.
18th March of 2025. PPO issued
Affidavit
on
of service
20th
filed on
of
behalf of the petitioner
February
is taken on
2025.
record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for disbursement of interest on delayed payment of gratuity and arrear amount from the date following the date of retirement till the date of actual payment, together with interest at the rate of 18% per annum.
I'm grateful, Lordship.
The petitioner contains that he was an assistant teacher
Lordship, in Railing High School, paragraph number 2, Lordship.
in Railing High School, post Railing district, Darjeeling. The petitioner retired from service on superannuation on 31st May 2024. The pension payment order was issued on 20th February 2025.
Lordship.
The gratuity and arrear amount was disbursed on 18th March 2025. However, no interest was paid, hence this writ petition. His submission same. %8% within a period of 6 weeks. Director parties 2 and 4. 2 and 3, sorry. 2 and 3. Respond number 2 and 3 are directed to disburse the interest amount. Disposed.
Grateful, Lordship.
5.
5 also similar, Lordship. It's a Five also similar, Lordship. Service. It's a single gratuity and arrears, my lord. Petitioner was superannuated on 31st of January 2025. Lordship and
Turnbull High School.
yes, Turnbull High School, Darjeeling.
PPO issuance
PPO was
16th May
issued-
2025. 27th May 2025.
5.
Year for the state?
Easy Lordship, State House Representative.
Same order, 6 weeks.
Grateful Lordship.
6.
6 also similar Lordship. Gratuity and idea. This is the service. Service. Petitioner is a assistant primary school teacher of Chongtong Primary School, Mary Wong, Darjeeling, Lordship. In
Chongtong
paragraph number
Primary
2.
School, Post Mary Bong, District, Darjeeling. 30th April 2022.
2.
14th May 2025 PPO.
Yes.
Disbursement 11 June 2025.
5.
6 weeks, 8%.
Grateful Lordship.
Seven.
7 Lordship. This matter is pertaining to die in harness Lordship for gratuity and area Lordship. The service. The petitioner husband was an assistant teacher of Khauga Primary School, Jalpaiguri.
Awagab.
Khawagao.
The
He died on 1st
Petitioners.
of 9, 2025.
petitioner contains that her husband was an assistant teacher of Hawa Primary School, District Jalpaiguri. Paragraph 2. The petitioner's husband died in harness on 1st September 2025.
5. Lordship.
The pension payment order was issued on 23rd February 2026.
6.
On 4th March 2026, the petitioner received the gratuity and the area pension. However, no interest was paid. ওপরের প্রেয়ারটা তো সেম থাকবে এখানে শুধু ডেট অফ following the date of death of the employee till the date of actual disbursement. 8% 6 weeks.
Grateful Lordship.
8.
8 Lordship. This is also pertaining to overdraw Lordship. This is the service. Petitioner has retired on 31st of October 2018 Lordship. He was an assistant teacher of Devahat High School, District Coach Bihar. Service.
This is about the deduction of money. I will have to
Yes, yes.
take instruction from the department whether they're outstanding or not.
It has been in the
By the
annex.
affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks for a refund of the
Deduction.
alleged overdrawn
Overdrawn.
of rupees 40537 deducted from the retiral gratuity of the petitioner together with interest at the rate of 18% per annum. Ms. Vanso, learned advocate appearing for the state respondents, seeks to file report. Let such a report be filed within a period of 1 week. Advance copy be served upon the learned advocate for the petitioner. Exception, if any, be filed within a week thereof. Liberty is granted to the parties to mention after expiry of such period.
Oblige, sir.
Such period is aforementioned period.
Nine.
Nine, Lordship, it's also gratuity and area, Lordship, single.
Gratuity,
Gratuity and area. Single PPO, Lordship.
when did you retire?
She retired on 30th/9/2016.
16.
Yes, Lordship. He's a secretary.
17.
Yes. He's a secretary of Panchayat, the Panchayat department, Lordship. He's in Panchayat department, Lordship. In paragraph number 2, Lordship. Paharpur Gram Panchayat under Jalpaiguri, Shodor block.
Yes. Mr. Ghosh here. Similar order can be passed. Similar order can be passed. Affidavit of service filed on behalf of the petitioner is taken on record. It is same by the present writ petition same. The petition contains that he was the secretary of Paharpur Gram Panchayat under Jalpaiguri Sadar Block, District Jalpaiguri. The petitioner retired from service on superannuation on
30th of
September 2016. Pension payment order was issued on 3rd February 2017. Gratuity and arrear pension amount was disbursed on 6th May 2017. However, no interest was paid. Like the same 6 weeks.
Grateful.
Delay clause.
In Lordship, it's also similar, Lordship. It's gratuity and arrear, Lordship, single PPO. In paragraph 2, Lordship, there is a
Assistant teacher of
Shukia
Sukhia
Pokri
Pokri
High
High
School.
School,
Shukia
post
Pokri.
Sukhia Pokri District, Darjeeling. Retired on superannuation 30th April 2024. Pension payment order 3rd December 2024. Gratuity and arrear amount disbursed on 27 December 2024. 27 December.
December, Lordship.
Rest same. You have for this?
Yes.
6 weeks, 8%.
Eleven.
11, Lordship, it's in matter pertaining to the die in harness, Lordship. Gratuity area, single PPO, Lordship. In paragraph 2, Lordship, the petitioner wife was a assistant teacher of Mathabhanga Girls High School, Kuch Bihar. She died on 22nd of March 2022. Payment order has been issued, Lordship, on 31st of July 2025. In paragraph 4, Lordship.
এটাই না এটা একটা হয়েছে আর তুই ওয়াইফ হাজবেন্ডের ডায়েট ইন হার্নেস একটা হলো না ওটা যদি চেক করে নেবেন তো ওর কোনো লিগাল ইয়েস আছে কিনা তাহলে ওখানে ওই অ্যাড করে দেবেন টু দ্য এক্সটেন্ট অফ দিস ইয়ার এখানে ছেলে আছে বাচ্চাটাকে মাইনর Why the minor son has not been made a party?
Lordship.
Not PPO there. As for the extent of share border.
Minor son has not been made a party. Minor son, though, yes.
Statement the kindly make it not to the after taking.
Sir, how can they be a party?
কালকে আসুন Tomorrow.
Legal guardian is to.
Well,
12, Lordship, it's also gratuity and arrear, Lordship. As per ROPA 2019. Revised PPO, Lordship, this.
Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner contains that he was an assistant teacher of paragraph 2, which Bihar. The petitioner retired from service on superannuation on 31st December 2017. Delay clause সার্ভিস ডিগ্রি রূপাটের কপি পেয়েছেন The first pension payment order was issued on 5th December 2017. The revised pension payment order under ROPA 2019 was issued on 23rd August 2021.
21.
The revised gratuity and arrear pension amount was disbursed to the petitioner on 30th August 2021.
1.
However, no interest was paid, hence this রূপা যা থাকে যেতে হবে না delay from 14th February 2020. ঠিক আছে till the date of actual payment. রূপার তো এখানে কোন ডিলে ক্লজ দিয়েছি আমি রূপার ক্ষেত্রে দিয়েছি দিয়ে দিবেন ঢুকিয়ে 21 সালের এটা দিয়ে দিন ডিলে ক্লজ from 14th February 2020 till the date of actual payment. State it clean. Madam is appearing for the state.
Yes, Lordship. 13 again, it's pertaining to die in harness, Lordship. Yes, affidavit of service. Petitioner husband was an assistant teacher of Shidhabadi Primary School, District Alipurduar. He died on 31st of January 2024, Lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for disbursement of interest on delayed payment of sessions at the rate of 18% per annum. The petitioner contains that her husband was an assistant teacher of Jalpaiguri Primary School, District Jalpaiguri. The petitioner's husband died in harness on 31st January
January
2024. The pension payment order was issued on 25th June 2025. The gratuity and arrear pension amount was disbursed on 2nd July 2025. However, no interest was paid, hence this petition. Submission same. 8% from the date following the date of death of the deceased employee till the date of actual payment. Affidavit of service. Disposed.
Okay.
14, Lordship, it's a revised PPO for gratuity and arrears, Lordship, as per ROPA 2019, Lordship. Petitioner is a headmaster of Nilkuthi Sister Nivedita Girls High School, District Coast, paragraph number 2, Lordship. He retired on 31st of December 2017, paragraph number 3.
Who died?
One died, Lordship. This is for ROPA revised PPO. Lordship.
Petitioner. Rupare Devan. The petitioner contains that he was she was an assistant.
She's a headmaster, Lordship.
Of Nilkuthi Sister Nivedita Girls High School, District Kuch Bihar. The petitioner retired from service on superannuation on 31st December 2017. First pension payment order was issued on 28th December 2017. Revised pension payment order under ROPA 2019 was issued on 24th November 2020. Revised gratuity and arrear pension was disbursed on 28th November 2020. 28, huh? However, no interest was paid. The same. Six weeks.
15 also. This is regarding, Lordship, gratuity and arrears, single PPO, Lordship. Petitioner was a assistant teacher of Pedwata Chandon Chauras SC Primary School, District Coachbihar, Lordship, in paragraph 2, Lordship.
He retired from service on superannuation on 29th February 2020. Pension payment order issued on
10th
March 2021. Gratuity arrear pension was disbursed on 2nd April 2021. However, no interest was paid, hence the writ petition. Delay clause 8% from the date following the date of retirement till the date of actual payment. 6 weeks.
Sixteen.
16 similar, Lordship.
Similar.
Single gratuity, single PPO, gratuity and arrear, Lordship. He was a headmaster of Milon Chongo Primary School, Lhasa Villa, Darjeeling.
Head teacher of Milon Songo Primary School, Post Lhasa Villa, District Darjeeling. Retired from service on superannuation on 31st May 2020. Pension payment order was issued on 26th November 2020. December 2020 disbursement.
Sir,
Following the date of retirement till the date of actual disposed of.
Seventeen.
similar lordship, single PPO gratuity and arrear lordship. Paragraph 2 lordship, the petitioner was assistant teacher of Nepali Girls High School, Nepali, Darjeeling.
Para 2, huh?
Para 2 lordship, paragraph number 2,
Retired from service on superannuation 31st December 2024.
2020.
PPO issued on 25th June 2025. Disbursed on 17 July 2025. Or no interest was paid. You have a state in, disposed.
Grateful lordship.
18.
18 also similar lordship, single PPO gratuity and arrear. The paragraph 2 lordship, he was assistant teacher of Vidyasagar High School and retired on 31st of January 2025. Paragraph number 2.
Paragraph 2. 31st January 2025, date of retirement. PPO issued on 25th April
5th of April
2025.
2025.
Date donation. 2nd May 2025, disbursement.
Yeah.
4 months didn't. Same. Next.
19.
19 also similar lordship, single PPO gratuity and arrear lordship. In paragraph 2 lordship, he was the assistant teacher of Arya Primary School, district Darjeeling, and he was retired on 31st of October
31st October
2022.
2022. 8 July 2024, CPO. School like Arya Primary School. 18 July. 11th August 2024, disbursement. No interest paid, hence this. Affidavit of service turning.
Service.
20.
Similar lordship, single PPO gratuity and arrear. Paragraph 2 lordship is a petitioner was assistant teacher of Lower Chongtong High School, district Darjeeling. He retired on 31st of March 2019.
April 19. This is ROPA, single PPO.
No, single PPO lordship,
Single PPO.
single PPO.
No. Para 1, it is ROPA.
No, lordship. There's no, it's under ROPA 9. Lordship, my mistake. It's revised gratuity and area under ROPA 19. Lordship.
The first pension payment order was issued on 10th April 2019. Stop. The revised pension payment order was under ROPA 2019 was issued on 25th October 2021. The revised gratuity and area pension amount was disbursed on 1st November 2021. However, no interest was paid, hence this repetition from 14th February 2020 till the date of actual payment. ROPA Jyoti.
That's an revise.
Yeah.
Yes, Your Lordship.
21.
21 Lordship is a single PPO gratuity in area, Your Lordship. Petitioner was assistant teacher of Lolegaon Primary School, Lordship. He retired on 30th of November 2023, paragraph number 2, Lordship.
23.
Yes, Lordship, and the revised order, the payment order was issued on 20th of May 2025,
Yes.
paragraph 5.
Amount disbursed on 24th June 2025.
20.
From the date following the date of retirement till the date of actual payment, 8% per annum. Affidavit of service.
Service has been done.
22.
22 Lordship, this is Diane Harness, single PPO gratuity in area, Lordship. Petitioner husband was appointed as an assistant teacher of Monaidara Tribal Primary School of Tagda, District Darjeeling, Lordship, and he was died on 13th of May 2023.
Petitioner contains that her husband was an assistant teacher of Monaidara Tribal Primary School, post Tagda district, Darjeeling. The petitioner's husband died in harness on 13th May 2023. The pension payment order was issued on 24th June 2024. The gratuity and arrear pension was disbursed to the petitioner on 12 July 2024. However, no interest was paid. From the date following the date of death of the petitioner's husband till the date of actual payment, 8%, 6 weeks.
Grateful.
Yes.
23.
23 also, Lordship, in Dine Harness, Lordship. Single PPO gratuity and area, Lordship. The petitioner wife was assistant teacher of Uttar Khapadi High School, District Coach Bihar, Lordship, and she was died on 5th of January
Petitioner contains
2014.
that his wife was an assistant teacher of Uttar Khapaidanga High School, District Coach Bihar. The petitioner's wife died in harness on 5th January 2014.
5th of January 2014, Lordship.
14.
2014. He was in service, Lordship.
14.
Yes, 14. He died during the service, Lordship.
The pension payment order was issued on 24th October 2019. The gratuity and arrear pension amount was disbursed on 20th January 2020. However, no interest was paid, hence this petition. Delay clause to thakbe. 6 weeks.
Twenty-four.
24, Lordship, is solved. Again, the single PPO, gratuity and arrear, Lordship. Petitioner was assistant teacher of Ahmad Jyoti Primary School, Darjeeling.
Hmm.
Paragraph number
31st
2.
May 2020 retirement.
Yes, Lordship. 31st May
School
2020.
para 2. Pension payment order issued on 4th January 2026.
14th of January.
14th of January.
No, Lordship, he
Amount
retired
is-
on 31st of May 2020. Then payment order was issued on 14th of January 2026.
Disbursement was in 19th February
February
2026.
2026.
No interest paid. Hence this repetition. 6 বছর পর। Where is the PPO? 26.
Page number 11, Lordship. Annexure P1.
Okay, 26. এটা direct cross থাকবে। Disposed of.
Correct, Lordship.
Twenty-five.
25 also, Lordship. Single PPO gratuity and arrear, Lordship. The petitioner was retired as an assistant teacher of Noyarut High School,
It is only gratuity.
Sahebganj High, Kuch Bihar.
Only gratuity.
Gratuity and arrear, Lordship. Arrear also, Lordship.
Where have you stated area? In prayer you have
Hospital
stated
payer.
gratuity amount? Gratuity, only gratuity. It is due to gratuity.
Gratuity, Lordship, it's a mistake, typographical mistake, but Lordship kindly sees that the last order was issued on gratuity and arrear only.
It's only gratuity amount. Not only in prayer,
Yes.
in paragraph 6,
Paragraph 6, Lordship.
this gratuity amount was disbursed in favor.
Yes, Lordship, it's Lordship, I
a
stand
contingent-
corrected, Lordship, it's only the gratuity.
Then petitioner content side it is to gratuity.
Gratuity
Assistant
amount,
teacher
yes, Lordship.
of Nayarhat High School, post Karala, PS Sahebganj District, Kuch Bihar. Retired from service on superannuation 31st December 2024. Pension payment order issued on 24th September 2025. Gratuity amount disbursed on 10th October 2025. No interest paid, hence this repetition. Interest and gratuity only. From the date, following the date of retirement till the date of activity. 8%, 6 weeks.
Twenty-six.
26, Lordship, is single PPO gratuity and arrears, Lordship. Petitioner was assistant teacher of Pitbhata Chandan Chura High SC Primary School, Kuch Bihar, Lordship. He was retired on 29th of February 2020. Payment order was issued on 24th of February 2021.
Disbursement of 5th March
5th
2021.
March 2022.
Same order, 8%, 6 weeks.
Lordship. Service.
Twenty-seven.
P7 Lordship, it's an dying harness Lordship. It's the revised PPO of under ROPA 2019, gratuity in area Lordship. The husband of the petitioner Lordship was an assistant teacher.
Husband?
Husband. Husband of the petitioner Lordship is a head teacher of the HON'BLE Junior Basic School, Coach Bihar. Was retired on 31st of May 2017, Lordship. He died on 11th of February 2019, Lordship, in paragraph number 6.
The petition contains that her husband was an approved head teacher of Jalpaiguri Junior Basic School, District Coach Bihar. The petitioner's husband retired from service on superannuation on 31st May 2017. The pension payment order was issued
On 19th of May 2017,
in favor of the petitioner's husband on 19th May 2017.
Lordship.
The petitioner's husband died on 11th February 2019. A revised pension payment order under ROPA 2019 was issued on 30th December 2024. A revised arrear and gratuity. Bro?
Yes, Lordship.
Revised. The pension was disbursed on 15 January 2025. However, no interest was paid.
Lordship.
Hence this writ petition. Okay, Rupar's submissions again from the 14 February 2020.
I'm grateful, Lordship.
28.
28, Lordship, it's a revised PPO. The petitioner was retired on 31st of January
Petition
2018.
is taken on record. Rupa.
ROPA 2019, Lordship. He was a head teacher on Shalmara
The petitioner contains
number
that
3.
he was an approved head teacher of Salmara Part Number 3 Special Cadre Primary School, District Coach Bihar. The petitioner retired from service on superannuation on 31st January 2018. The pension payment order was issued on
1st of
1st
February
February
2019.
2019. The revised pension payment order under ROPA 2019 was issued on 29th November 2021.
21.
A revised gratuity and area pension amount was disbursed to the petitioner on 5th December 2021. However, no interest was paid, hence this writ petition. The rest same. From 14th February 2020 till the date of actual payment. What's that? Affidavit. Next.
Grateful, Lordship.
29.
I beg to appear on behalf of the petitioner. This is a land acquisition matter. Kindly takes up the last order dated 9th of June passed by your lordship, my lord.
This, it is observed that despite repeated orders passed by the Honorable Court, the actual payment of orders has not been made and response is directed to file a report showing. No. Isha Acharya, the proper release is 12. Yes. Mr. Misra, what is the
If I can have a moment on a couple of paragraphs of the resolution. Beginning with paragraph 8. It is a contention of the resolution of paragraph 8. And I'm just about the table. That in this case from 1963, the period of the notification was there. And based upon that notification, the land was acquired. The petitioner claims that his 5 decimals of land has been acquired. It was 63 years back. I have a moment on the next page. He again says that for more than 48 years in paragraph 6, he has been struggling to find out as to what the component of compensation would be and how much he is entitled to. The affidavit of the petitioner, page 11, his age is 35 years. Now, based upon the last order that was passed by the Honorable Court, the department has sent a payment voucher with receipt to the acquiring body. The acquiring body has sent instruction that in 1999, an amount of 48,794 has already been disbursed. Out of which the compensation, the land, the expropriate owners at that time were paid 2,974, and the rest of the money is lying yours. If they can show the proper documentation, because this was discussed in favor of Kusumbala Burmani, Halua Burman, Nishikant Burman, who most probably were the respected forefather of the petitioner. Mundai Chandra Das, Nrityendra Burman, Dhirendra Burman, Bhukhu Burman, Harinadu Burman. Now this amount has already been disbursed to us, therefore a question of repeated compensation does not arise. If they can show the proper documentation and proof, and along with the family tree as to who has received the compensation and who hasn't received, then in that case, not out of 48,794, 2,974 disbursed, the rest amount is like capital. I have only one copy of the instruction here. I'm so sorry. I will give them a copy. So the case is there. 1990 first. Just in case if they haven't received, then 48,000 minus 2,700 and whatever, that amount lies to 47,000. That 47,000, as per the entitlement on a pro rata basis, will be paid to them. So kindly takes up page 84 of the regulation. Look, the market value was calculated as per direct purchase company. Thereafter, the special land acquisition officer has requested for funds before the executive engineer. Thereafter, there has been no progress in the requested matter.
page 24?
Page 24 of the requisition. Third line.
Yes.
Thereafter, they have filed a report stating that the payment has been approved and the petitioner will receive the compensation within 2 months.
Where is that?
On behalf of the respondent number 8. That is the last report. Second report. Report in the form of affidavit filed by the respondent number 8.
8 or 7? Respondent number 8 or 7?
Respondent number 8. 7 has filed the report, whereafter respondent number 5 has filed the second.
What is the date of the report?
January 2025.
January 25.
Page number 8. Paragraph number 19. Because in my copy there is no page number 8.
19.
Paragraph 19. Thereafter compensation was reduced to 1.17. And the last paragraph, my lord, will also take up alert that they have given an undertaking within 2 months it shall be paid to. Till date, no compensation has.
Based upon that development of fact, we have sent a asking for payment voucher and everything. Because in the report, there is a paragraph that says that because this case is 63 years old, we do not have the documents of that case. Some payment vouchers were retracted. Those payment vouchers were sent to the authorities. Then we came to know that the compensation has already been deposited in 1990. That is what it says.
This report is
And
one and
out of that 48,000 deposited in 1990, the forefather of the petitioner, they have already received some quantum of compensation. The rest is lying with the registry. That is what the report says.
But
So all this
what
question
about-
was there. This determination and the order of the report was there, believing on paragraph 1, 2, 3, 4 of the writ petition, saying that no compensation has been received. That is not what the fact is. Now, what has transpired from our report is that in 1990, compensation of 48,700 something was already deposited.
Okay.
So now
Then-
nothing to suffice in the writ. They can
But
go and
what-
collect it from the residue, showing their family tree and their proof of the land as on today.
But what about the report that has been submitted by the
Yes,
special?
yes, after that report, sir, after that report, it has to be sent to the requisitioning body for the release of fund. It was sent to the requisitioning body. Then the requisitioning body came with an opinion that no, in this particular project, the compensation was already deposited in 1990. So all these calculations that we have done and everything that was done there, now stands awaited. Because compensation has already been paid. Nobody can be paid compensation double or twice or 2 times for the acquisition of the same land. In that report itself, it says that the documents previously were not available because this is a 63-year-old case. But based upon certain payment vouchers,
Certain copies of the voucher
fund was
payment
asked for
voucher.
from the acquisition one.
Oh.
And the expropriate landowner in whose favor compensation has been paid is also showing there. One of them maybe is because from the affidavit, his father name is clear, but his forefather name is not clear, which obviously will not be there. So now they need to show their family tree and everything, succession certificate, and then they can collect that amount that is already deposited in 1990 in the treasury.
What is the order passed by the Special Land Acquisition Officer after the order passed in WPA 2441?
That point has already been taken care by His Lord's Honorable Justice Sampashar.
What is the order passed?
I managed to petition, that is page 17, order passed by Justice Sarkar. Respondent number 6 was directed to consider the representation
What is the order first?
page 17 below.
What is the order passed pursuant to the order passed in the writ petition?
That is at page number 23.
20.
Reasoned order passed by the special land acquisition officer. Page 23, my lord will take up. My lord,
Yes, yes. Good.
page 23, order dated 6 March 2023. Milord, here they have admitted, Milord, that the land has been acquired without following the due process of law. Thereafter, the direct purchase committee has filed its report assessing the quantum of the compensation which was to be paid by the petitioners. And they have sought for funds on the next page.
So, Mr. I suppose an affidavit has to be filed because if you retract from your earlier stance, now after the,
I explain.
no. You come to page 23
Yes, ma'am.
and pursuant to the order passed in the writ
Yes.
petition, you say that they have to be compensated.
Yes.
That means on the date you are passing the order, no such no, that you have to say, no? Because until and unless that comes in the record, that the earlier orders that were passed, that is not in consideration, that has to be examined, whether that has been paid or not. And also, see, since you say that there are vouchers of showing that some of the legaliers have received some amount
Yes.
and the rest amount is lying with the department. The court in its order dated 22nd December has referred to the order passed in the writ petition WPA 2441.
These acts were not brought before the court, now it has to be brought by way of affidavit. All these orders that has been passed by the honorable court below, that has been passed because of paragraph 6.
Orders were passed based on their report.
Sir, wait. Because of paragraph 6 of the writ petition. In paragraph 6 of the writ petition, they say that for more than 48 years, no compensation has been received by them.
Hmm.
So that was the basis upon which everything has happened. Now, when we put forward the case before the requisitioning of authority for payment of compensation based upon the new calculation, then the requisitioning of authority based upon the payment voucher said that no, in this case compensation has already been passed.
Okay.
This is the basis something that I will have
Mr. Jagriti Misra, Learned Assistant Additional Advocate General, submits that though previously the page 23 now. Special Land Acquisition Officer Kuch Bihar passed order pursuant to the order passed in the writ petition being WPA 2441 of 2022, holding that the petitioners are liable to be compensated in terms in respect of land measuring 0.005 acres which has been acquired by the PWD for construction of a road, and the market value of the land was assessed, be that as it may, after the reports were sought for from the requisitioning authority is the requisitioning
Assistant Secretary, PWD, Government of West Bengal.
Requisitioning Authority, Special Secretary PWD, Roads. It has been disclosed that previously the predecessor in interest of the petitioners have received the compensation amount the compensation amount was assessed at rupees 48,794 in the year 1990, and some of the predecessor in interest of the petitioners have already received the compensation amount. Therefore, the petitioner cannot claim further compensation on the land which was previously acquired and compensation assessed.
Kindly, because my objection to the not receive any compensation.
He seeks to file a supplementary affidavit. He has filed affidavit in opposition.
We will find a supplementary.
Seeks to file supplementary affidavit in opposition to bring on record such fact. Learned advocate for the petitioner refutes such claim.
Previous order, it's a direction.
As per the previous order, the state respondents were directed to disburse the amount in favor of the petitioners. The estimated cost of which is 1,17,12,962 approved by the Finance Department. With response number 8 will find. Response number 8, such and such, is directed to file supplementary affidavit in opposition. Earlier you have filed your affidavit in opposition.
Yes, you have done.
Supplementary affidavit in opposition with regard to the submissions advanced at its end
And the new developments.
and the new developments.
And the judge.
Advance copy within a period of 2 weeks. Advance copy will serve. Affidavit in reply, if any, be filed within a week. Liberty is granted to the parties to mention after expiry of the aforesaid period. Sure. Next.
And
Which one? 30.
Yes. I'm appealing for the respondent number 4.
Pursuant to your lordship direction, we have served upon the state. Last occasion, your lordship was to direct, serve again. We have served upon the state also.
But a state is here, but possibly, my lord, the regulatory commission, they have their own panel of lawyers. State was here on the earlier occasion also.
Which respondent? Which respondent?
2 and 3, my lord. Another thing, my lord, is my learned friend kindly serve with us with a legible set of annexure. So, কিছু পড়া যাচ্ছে না।
I have the legible copy, I'll have it right next.
West Bengal.
It was all sent to me by scan copy was sent.
বুঝতে পারছি,
I'll have it.
And I am, as on the last occasion, Lordship, I have raised the issue of maintainability of this petition.
You are regulatory commission.
No, I am for the respondent number 4. At the behest of my complaint, Lordship, the National Commission conducted a hearing and passed an order, thereby directly imposing a cost of rupees 20,000. That order is being challenged by way of this petition by them.
Okay.
Lordship, review order is at page 86.
86.
At page 86, except P4. What happened in Patari Lordship? Point number 4. His mother was admitted in our hospital. And she was undergoing a treatment. Thereafter, subsequently, on he felt treatment is not going well. He requested for discharge. This is in medical term is called LAMA. Leave against medical advice. Respondent number 4's mother was in critical condition. She was in ventilation. Respondent number 4 asked for LAMA leave against medical advice. And his main contention in the petition of complaint is that there are some other complaints regarding treatment as well as uncleanliness in the ICU. And the main complaint is delay in discharge.
Dada.
His complaint was, we have filed requested for delay at discharge was made at 8 p.m. There was 6 hours delay in the discharge on the request of LAM. The Honorable Commission is a health commission, your lots of knows. Honorable Commission while dealt with the complaint made by the respondent number 4 regarding this medical negligence. Honorable Commission held he has already filed an application before the medical council that is not within the purview of the commission. And regarding the uncleanliness, Honorable Commission directed the department concerned to give a surprise inspection to the hospital concerned. But pertaining to the delay in disposal, discharge against LAMA, the Honorable Commission held, since there was delay, I am imposing a cost of rupees 20,000. But the 20,000 cost is not the criteria. Criteria is whether there is delay or not. That is the main contention of this petition. Proceed to the petitioner, the delay, the Honorable Commission was pleased to held without any explanation. This order was passed. And against challenging that order, we have preferred this writ petition. And the my friend is submitting that this petition is not maintainable.
You have filed your application before the West Bengal what committee is this?
Before
Regulatory.
regulatory commission, we had filed our application before the regulatory commission, and that was adjudicated, and this order was passed.
What is the Lordship, there is at page number 81. Page 81, the complaint, annexure P2.
Okay.
Lordship, relevant page is page 82. Bottom portion. Then I decided to shift my mother to another hospital at 2 p.m. But unfortunately, I have got no response from the hospital authority. At last, I went to ICU and told them why they are taking so long time for the patient discharge. And they replied that there are some mistakes at the time of preparation of LAMA summary. So I paid all the huge amount in middle and discharge after 8 p.m., which is very absurd and long duration. After taking to to another hospital, my mother's treatment was started under CP Sharma at the nursing home. But after 1.5 hours treatment, my mother died at the nursing home. I am very upset for my personal loss because I consulted Dr. Sudipto Pramanik on Neutia Gatewell for periodical checkup dated so and so. I personally told to doctor that my mother is coughing from last 2 to 3 days. So after checking her by stethoscope, doctor suggested ascoril so and so and test for diabetes packages to repeat. Thereafter, I went for the test on 9 2025. Really, I was a very nasty and bad experience in Neutia Gatewell Hospital, Matigara, where all the dustbins and ICU are open near my mother bed. All the reports are very attached with therewith for easy understanding and necessary action for inquiry for the negligence. Lordship, against the CU, there are two negligence allegations. One is delay in discharge and dustbin is placed.
C is
C, clinical establishment, your lordship. Clinical establishment, your hospital, nursing home, the Honorable Commission, in short, they used to write the C. So, lordship, in page 83, we have replied. We have submitted this reply before the Honorable Commission. Lordship, what are the procedures we have undertaken in our hospital when the patient was admitted, when the patient was getting treatment? Lordship, it is at page 84. Lordship, last part, three paragraphs. Mrs. Kukulahiri was taken out of invasive ventilated support on 14/5/2025 and put on non-invasive ventilatory support via face mask. The patient underwent CAG on 15/6/2005 under the supervision of Dr. Rajesh Nandal. CAG, Lordship, CAG full form is, you kindly allow a moment.
Lordship, may I only indicate one thing, Lordship?
Lordship, coronary angiography.
My lord, may I be permitted to mention one matter, my lord, for withdrawal?
Mention tomorrow.
My lord, today, my lord, I've came here, it was supposed to be listed today, but it has not been listed.
Mention tomorrow in list. Yes.
Uh, I am referring to page number 84.
Yes.
Page number 84. At 2 p.m. according to the correspondent of 4. Request for discharge on Lama was placed. And on 14/5/2025, on the date when patient was discharged. Not sorry. Registration 760. On page 84, what was the procedure going on? Since the admission of the patient at the hospital. This is Kokul ID, third paragraph from bottom. This is Kokul ID was taken out of invasive ventilated support on 14/2025 and put on non-invasive ventilated support via first mask. The patient underwent CAG on 15/6/2025 under the supervision of Dr. Rajesh Nanda, MB, DNB, cardiology, and thorough counsel of patient study. And after obtaining informed consent for CAG from the patient family. CAG is coronary angiogram. This was done on 15/6. Thereafter, NIB dependent non-invasive ventricular support. NIB stands for non-invasive ventricular support via face mask. Dependent with required blood pressure support. However, antibiotic escalated on 15/5/2025. And so, in view of high WBC count, white blood cell count, patient Enoki desired to take the next to the king. Desired to take the patient to higher center, which was however not agreed to in view of our unstable hemodynamic condition on NIV. But see, the patient's condition was very serious. In spite of his request, the treating doctors was not agreed to discharge the patient at that juncture because our physical condition was not so much stable to transport to another establishment. However, patient Enoki still insisted for discharge against medical advice. The high risk during transportation, including sudden death, have been clearly explained to patient and their family members in their own language, which they understood well. That's what we stated before the Honorable Commission. Nothing finally comes to page number 8, page number 17. Page number 17 is Lama, leave against medical advice.
Page 70.
$16, 16. Annexure P1. From the very beginning, what the patient was undergoing, at what condition the patient came, and what treatment was administered to her, it has been written. That's it. Kindly comes to page 70. Course and treatment in hospital. Second paragraph. That's why I am reading out from the last sentence. The patient was also referred to and seen by Dr. Swanso. At present, the patient is in shock and under vasopressor support. The patient now wants to take Lama, and all the risks associated with transport has been explained. Patient is currently NIV dependent in view of onset aftershock antibiotics were upgraded on 16/5/2025. The condition of the patient has been explained to our NOK in their own language. Patient's NOK opted for discharge leave against medical advice. Hence, patient B was medical advice. The high risk of transportation, including sudden death, have been thoroughly explained to the next of kin of the patient in their own language. Lordship, here it was, this lama was given to the respondent number 4 when the patient was discharged. Now, Lordship kindly comes to next page 18. The lama advice has been explained to me in language understandable by me. This is Lordship signature of the respondent number 4 son. Lordship, that the main concern of the respondent number 4 is from 2 p.m. till 8 p.m. what the patient was, why there is delay of 6 hours in spite of this law. And your Lordship kindly comes to the impugned order. That is at page 9. So I stand to be corrected and it comes to page 89. It starts at page 86, impugned order, and the relevant portion is at page 89. On the dustbin issue, we direct CMOH Darjeeling to make a surprise inspection to find out veracity of the allegation and submit a report to us at an early date. Also, I have submitted that the concern of the CE is to look into the procedure of treatment adopted by the CE, not the medical negligence. That part, the Honorable Commission has taken note of that. Since the medical negligence is in the hands of the medical council, we do not go into. Now the next part is dustbin concern. COH has been directed to make a surprise inspection. Now, Lordship, we are not impressed with the stand taken by the CE with regard to the delay in discharge. Lordship, no explanation, no delay at all. We have categorically stated in our written notes reply what was the delay, and all medical papers, internal assessment were submitted before the Honorable Commission. I'll show your Lordship what was the procedure adopted and why the patient was given treatment. When the patient relative of a critically ill patient would ask for lama or dama, it would be the duty of the CE and of the patient treating team to properly counsel the patient relative as to the risk involved in the transfer process, and such counseling must be documented. Lordship, we have in our lama, it has been categorically stated the patient part next of the kin was explained about the risk involved regarding the transportation of patient. This was not dealt with by the Honorable Commission while dealing with the complaint. Kindly comes to the next paragraph. In this case, we do not find any such attempt made by the CE. The complaint submitted the lama application at 2 p.m. and the patient was discharged at 8 p.m. after about 6 hours. We deprecate this practice despite being cautioned about the risk involved. If the patient relatives want to shift the patient otherwise, else the CE must take immediate steps to have the patient transported to the other establishment. Such process has to be followed. All such cases, the complainant has already approached the West Bengal Medical Council as against the treating protocol. We do not wish to escalate the issue being outside of our domain. We impose a penalty of rupees 20,000 because of the unusual delay caused by the CE in discharging of the patient. This is the finding. This is the directives, and the finding is this. We are not impressed with the stand taken by the CE with regard to the delay in discharge. Thereafter, Lordship, the Honorable Commission went on. When the patient relative of a critically ill patient would ask for lama or dama, it would be the duty of the CE and the treating team to properly counsel the patient relative as to the risk involved in the transfer process, and such counseling must be documented. Lordship, I have shown to you Lordship the lama at page 16, where it has been documented. Now, Your Lordship, I want to show another document at page 18. At page 80, Your Lordship. This is the internal assessment of a patient when a patient is being admitted, what are the treatment going on and what the treatment administered to the patient. It has been documented, all documented in common. We call this as a bed head taken. BHT. It starts at page 77 of the dated 16/5 when the Lama was asked for. Starts at page 77 on the left hand corner, top 16/5/2025.
So what is the
At the
reason
time,
of, what is the
11
reason of delay?
That's it.
What is the reason of delay?
Lots of patient was administering treatment. She was in NIV, non-invasive ventricular support, face mask. She was lots of kindly comes to at page 80. Daily care plan, so and so, snack in evening.
No, what is the
replacement
reason of
40
delay? This is the condition of the patient.
No, lots of kindly NIV support to continue. We are assessing the patient. Patient is being administered treatment.
Hmm.
Continuous treatment is being given, and patient was preparing for discharge. USG chest SOS ABG at 8 p.m. ABG means arterial. Tell the exact term. Arterial blood gas analysis. This was supposed to be done at 8 p.m.
Where is your dated ticket for the date on which the application was made from 2 p.m. to 8 p.m.? What are the necessary steps that were taken?
Entire process.
When was the application made?
Application was made on 16th.
16th May.
16th May.
Where is that 16th May?
It starts at 77 your worship.
77.
77. Enter 16th May treatment is documented. Page 78, clinical examination, oxygen therapy. Everything was continuing, your lordship, and the patient was preparing for discharge. So there was a critically ill patient. Once the Lama is asked for, cannot be discharged immediately without preparing the patient to be transported.
After 2 p.m. After 2 p.m. on 16th. What is the steps taken? What is the time? Page 77 is 10 a.m.
10
10
a.m.
a.m. the application was not filed at that point of time.
No.
After 2 p.m. what the steps were taken, you say?
From page 77 to 80, the entire treatment procedure undertaken to the patient.
Come to page 80. Page 80.
Page 80.
Page 80, there is a signature of the attending doctor. It is 16th May 2025. He puts the date as 10 a.m. Application was made at 2 p.m. From 2 p.m. to 8 p.m. What are the steps taken on 16th, which has stopped the authority from discharging the patient to be shifted to another place? Nothing.
Lordship, I have the medication chart that have not been annexed. You kindly, your lordship kindly.
And nothing has been, 16th May, he made an application. 16th May,
16 May on, they have made application.
the 16th May in the reply also there is no explanation. 16th May after 2 p.m.
Page number 82.
82 is their complaint.
84 is our reply.
In reply also there is no explanation. What happened after 16th May 2 p.m. till 8 p.m.? No explanation. Awesome.
Lordship, may I indicate one thing, Lordship? We have made a complaint regarding delay of release of the patient, Lordship. Subsequently, a explanation was called from the board, from the West Bengal Clinical Establishment Regulatory Commission, Lordship. They have given a reply. The entire thing was adjudicated, entire thing was considered. Thereafter, the establishment regulatory commission has come to a finding, Lordship. Now, Lordship, my first question is regarding to the maintainability. There's a provision of appeal. And moreover, he is disputing the fact. Where is the jurisdiction of the writ court to enter into disputed questions of fact? There's a provision of appeal, letter. Section 41, appeal provision of the West Bengal Clinical Establishment Registration and Regulation Transparency Act 2017, Lordship. If they are aggrieved by this order of the regulatory commission, they have to prefer an appeal. Who can look into these disputed questions of fact? Moreover, he is not ventilating any grievance regarding violation of the principles of natural justice or procedural lapses. So that is,
Which is the provision?
this order is
41.
Section 41, Lordship, appeal provision.
No, this order has been passed by whom?
This order has been passed by the West Bengal Clinical Establishment Regulatory Commission.
Appeal you are showing it's of the adjudicating authority.
Yes, Lordship. Section 36 is the constitution of the West Bengal Clinical Establishment Regulatory Commission. Thereafter, Lordship, 41. Kindly see.
No, if your order is passed by the regulatory commission,
Lordship.
it will be challenged before which authority?
The appellate authority, Lordship.
41 says that orders and decisions of adjudicating authority in district shall be appealable before the West Bengal Clinical Establishment Regulatory Commission. This order which has been challenged is passed by the regulatory commission.
Also, may I? Section 42 speaks for appeal before the Honorable High Court.
High Court.
42. And Lordship, since
We agree that it is
since
a
the establishment of this
tribunal.
commission, all the challenges are of the order passed by the Honorable Commission are being made by writ petition before the Honorable High Court. There are several judgments. I am qualified with.
You have referred to which act?
West Bengal Clinical Establishment Registration, Regulation and Transparency Act 2017.
17.
2017. Hmm?
2010. 17.
Huh? কতটা তো আছে? না না
No, the order passed by the commission is appealable before which authority?
not sure. Section 46 says civil court not to have jurisdiction. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which an adjudicating authority or the West Bengal Clinical Establishment Regulatory Commission is empowered by or under this act to determine.
Order passed by the commission is appealable before which authority?
No, there is no. 42 alerts.
Section 42 of?
Of the act.
42, the salary.
No, 41.
So 41.
High Court.
Which is the key.
Forty-one is the adjudicatory authority's appeal. Adjudicatory authority's decision will be challenged in appeal, and 42 is Honorable Commission's tribunal's decision is to be appealed before the High Court.
अच्छा. Order 26. No, 26, appeal to appeal. No.
Section 36 doesn't do.
ওটা অন্যটা। 26 অন্য। appeal to authority যদি লাইসেন্স ক্যান্সেল করে দেয়। খুঁজে দাও তো খুঁজে দাও। খুঁজে দাও। খুঁজে দাও।
Where is the provision of the appeal?
So the My understanding it was 41, but 41 is against the order of the
So when will
adjudicating
the
authority
Act
before
of
the.
2017 apply and when the Act of 2010 will apply? What is the difference between the both acts? There are two acts. One is West Bengal Clinical Establishments, which we have placed Registration, Regulation, Transparency Act.
Lordship,
This is of 2017.
2017.
There is another act which is West Bengal Clinical Establishment, Registration and Regulation. Transparency, what is not there?
Lordship,
It is of Act of 2010.
2010.
The appeal provision which we have shown, it relates to the adjudicating authority passing an order, it is appealable before the commission.
Commission.
What happens to a commission if it passes an order? Which is the authority to take up the appeal?
Lordship, in our, after this submission of this 2017 Act, all challenges of the order passed by the Honorable Commission has been made in before the Honorable High Court by exercising writ jurisdiction. These are the orders. Lordship, this is the order of the WPA by Honorable Justice Krishna Rao of our.
And the commission.
Following which provisions again?
This is an order of passed by this circuit bench, Jalpaiguri. All these orders arises against in a writ petition filed against the order of the Honorable
Commission.
Commission. Lordship, this is a division bench order of our Honorable High Court. This is there was a order passed in a writ petition challenging an order of the Honorable Commission. Thereafter, in the writ petition, an order was passed for inquiry and report, and report was filed challenging that report. The writ petition was filed against that. This appeal was filed. All lordship arose out of an order passed by the Honorable Commission, which was challenged before the writ petition. Nowhere this maintainability point was taken up, and Honorable High Court, while dealing with these writ petitions, never dealt the authority of the Honorable High Court, the jurisdiction of the Honorable High Court, sitting on appeal in writ jurisdiction.
এটাই তো ওই তো 261
Here, Your Lordship, the Honorable Commission, while dealing with the complaint, dealt with the medical negligence matter, and against that, this writ petition was filed.
Okay.
appeal against order of Westman Clinical Establishment.
Your Lordship, I am also referring to a judgment passed by the Supreme Court of India in Whirlpool Corporation. Here, Your Lordship, Honorable Court held. Para number 14 to 21. If an alternative remedy is available, the writ court has power and jurisdiction to entertain an order where principle of national justice has not been followed.
ABC জানলেন
But there is no provision of appeal.
ফালতু আছে
Section 42 says, Your Lordship, that appeal will be to the Honorable High Court. And all appeals are filed in the form of writ petition to the Honorable High Court.
42 of
42 of the Act,
Which is-
2017 Act.
1742 is salary allowance.
Lordship, may I have, there is, I have a fact mark. I mean, I mean. I stand to be corrected, Lordship. This is 2010.
10.
2010, 10, Act. Again, the provision of appeals that there are two or like
সেকশন কত বললেন?
2010.
42.
This is the order of the tribunal, not commission.
Tribunal. There is also for tribunal. There is no provision of, there is this against in 2017 Act, Lordship. There is no provision has been incorporated by way of any statute. The procedure for challenging the order of the Honorable Commission. So all challenges are being made in the form of writ petition before the Honorable High Court. In three cases, your Lordship, judgments passed by our Honorable High Court. Writ petition was entertained and disposed of accordingly. Deal with the
Any other ground? Is Mr. Bhattacharya?
Lordship,
The main answering respondent is the regulatory commission, madam.
They are not
Private
appearing.
panel, we do not represent, they have a separate panel of lawyers.
but however, Lordship, I would like to focus on the point that they have failed to show that whether what steps they have taken after lodging of my complaint for release of the patient.
Ashwin. Affidavit of service filed on behalf of the petitioner is taken on record.
Lordship, before passing.
By the present writ petition, the petitioner, no. By the present writ petition, the petitioner seeks for setting aside and a cancellation of order dated 13th October 2025 passed by the Secretary, West Bengal Clinical Establishment Regulatory Commission in complaint number
Also, sorry.
WB WBCERC/DAR/SMP/101/2025-26.
Lordship, by of supplementary affidavit, I can bring the records regarding the treatment procedure taken up
By the
post to be.
The reply is enough. The petitioner Neotia Gatewell Multi-Speciality Hospital, a unit of Ambuja Neotia Healthcare Venture Limited, is a multi-special well-equipped hospital. Which place this is situated in? Siliguri?
No,
Matigara, madam.
Matigara, hospital is Matigara,
Situated at Matigara,
Siliguri.
Siliguri district, Darjeeling. In the said establishment, the mother of respondent number 4, namely Khuku Laidi, was admitted on 12th May 2025 at 7:07 PM in a state of asystole. এই দেখুন প্যারা 4A বানানটা দেখবেন, cardiac arrest, and was promptly recognized and given CPR. Full form is
CPR. CPR is,
CPR at emergency before being intubated.
CPR.
and was put on mechanical ventilator support by doctors in the emergency department. After initial stabilization, she was shifted to ICU bed at 11:30 p.m.
So CPR stands for cardiopulmonary resuscitation.
Cardiopulmonary resuscitation.
देखिए इसको निफ्टी फिफ्टी देखिए मार्च 74 নেমে গেছে
On 13th May 2025, after the sedatives were stopped, the mother of respondent number 4 was awake but very restless. So she was given mild sedation as required. Stop. She was improving but still required mechanical ventilation. CT scan of chest showed bilateral lower lobe pneumonia and echocardiography showed poor cardiac function within bracket LVEF 20%. Stop. Her TLC total leukocyte count was raised and the patient was managed as per standard ICU protocol with antibiotics and other supportive treatment. The condition of the patient was explained to respond number 4 in detail by the attending doctor and other clinical staff. The respondent number 4 asked the doctors to remove his mother's ventilator support immediately. He was explained that withdrawing ventilator support is a gradual process and is usually done when all the clinical parameters are suitable. However, respondent number 4 showed dissatisfaction with the hospital authority. On 14th May 2025, the mother of respondent number 4 was taken out of invasive ventilator support and was put on non-invasive ventilator support via face mask. On 15th May 2025, the mother of respondent number 4 underwent CAG, coronary angiography.
Also, can you allow me at page 76, 6 p.m. at page 76, the treatment what the patient was administered medicines at 6 p.m. is given.
Six PM.
কই তার টাইপি না না কোথায়
কি বলো?
this can't be বিমল
Angiography. The patient being the mother of someone 4 remained NIV within bracket non-invasive ventilation. bracket close, dependent with required blood pressure support, antibiotic escalated on 15th May 2025 to meropenem.
On page 73, entire treatment of 65 is given on page 73. Patient was on BiPAP. Clinical hostility, patient's medical unit, BiPAP support.
The patient's relatives, being respond number 4, requested for LAMA, leave against medical advice or left against medical advice on 16th May 2025 for shifting the patient to a higher facility setup center. The patient was discharged by the petitioner on 16th May 2025 against medical advice from the treating doctor. There is no iota of negligence and flaws on the part of the petitioner in treating the patient. On 18 September 2025, respondent number 4 lodged a complaint before respondent number 2, being the West Bengal Clinical Establishment Regulatory Commission, which was registered as case number 2 against the petitioner hospital. Contending of harassment and delay in discharging the petitioner from the hospital. The respondent number 2, West Bengal Clinical Establishment Regulatory Commission, upon hearing, imposed a penalty of 20,000 on the ground of unusual delay caused by the clinical establishment within bracket in short CE in discharge of the patient. Being aggrieved and dissatisfied with the impugned order, the petitioner has filed the present writ petition. Mr. Swansol, learned advocate, appearing for the petitioner, submits that the hospital authorities have taken all measures to make the patient stable. The patient was suffering from acid stool and there is no such negligence on the part of the hospital. The discharge of the patient took time due to the critical condition of the patient. Such aspect has not been dealt with by the commission. Accordingly, the same is liable to be set aside. According to the impugned order of the commission is liable to be set aside. Now your ground of this is appealable order is not standing.
Lordship.
Huh?
However, Lordship, I will only say that in the reply to the query sent by the commission, they could not demonstrate that what effective steps they have taken for early release of the patient. Nothing. Page number
Mr.
83,
Devorshi
84,
Dhar, on the
85.
contrary,
All these
Mr.
documents were
Devorshi
placed by the commission.
Dhar,
Yes,
learned
all these documents
advocate
were placed before
appearing
the
for
commission.
respond number
Commission
four,
considered four.
submits that no effective steps were taken by the hospital authorities for early discharge of the patient. He seeks for dismissal of the writ petition. Upon going through the upon hearing the learned advocates for the respective parties, Kunalji Bhattacharya submits that state is a party here.
Yes, the state is a party, madam. And I'm being, state ballot, I'm supporting the.
Learned additional government leader supports the contention of the respond number 4.
No, but I cannot support it. I'm saying that the
Commission.
commission has reached to a correct finding.
Support submits that the correction commission has rightly held that there was unusual delay caused by the hospital authority in discharging the patient. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the finding of the West Bengal Clinical Establishment Regulatory Commission, respondent number 2 of unusual delay caused by the CE in discharging the patient is sustainable or not. Admittedly, the discharge of the patient was sought for on 16th May. 16th May at 2 p.m. and the patient was discharged at 8 p.m. after 6 hours. Before the commission, the CE filed its reply to the complaint lodged by respond number 4, which has been dated 26 September 2025, which has been annexed to the writ petition being
Along with all this patient.
annexure P3, page 83.
Okay.
Upon-
Along with all this internal,
Upon going through the reply before the filed before the commission, it is found that there is no such explanation given since 2 p.m. at 16th May 2025 till the discharge of the patient at 8 p.m. regarding the delay in discharging. Therefore, the findings of the commission regarding the delay in discharge of the patient is held to be not infirm. Accordingly, the writ petition falls short of merit. The order impugned does not call for interference. Dismiss.
Lordship, kindly appreciate.
No.
Before the honorable commission, we have filed all these documents pertaining to the treatment undertaken before the hospital.
Next.
I am for the private respondent.
But I am for the state, my lord, before my.
I am for the
learned
petitioner.
friend For the petitioner starts. On Saturday, my lord, I had received a preliminary instruction. Today, about an hour ago, my lord, I received all the instruction. Can it be taken up tomorrow, my lord?
What happened? It is
No,
demolition.
application is before an authority, when the authority has not yet decided anything. Let it be placed before the authority for taking this a reasoned decision, my lord.
My lord, I have some instructions. Let me come back tomorrow, my lord. So, because
I may
the
be granted an opportunity of hearing there,
executive officer, my lord, of
You
the
have made
Matigada
unauthorized
Panchayat
construction.
Samiti,
my lord.
You have made unauthorized construction.
No, they allege, I've been residing there for the
that
past
is-
70 years.
It is
Some-
authorized.
The
some-
buildings are old.
my lord, as per my instructions, some hearing had taken place. The inspection had also taken place, my lord. That report is not with me, my lord. So if your lordship kindly
You were
takes it up
present in
tomorrow.
inspection.
Yes. That, my lord, I will see, my lord, because what I have preliminary seen, my lord, names of the parties are there, whether petitioner was there or not, I don't know. Kindly takes it up tomorrow, my lord, I'll assist your lordship.
Not to.
Thirty-two.
32 for
Miller
the,
time for the petitioner.
32
Miller's
lordship
mic.
for SGD, I am led by Mr. Arjun Rai Mukherjee.
I'm for the state, my lord.
Miller's my grievance is against the non-allotment of the developed plot under rehabilitated and resettlement scheme by the respondent authorities SJD. Miller's, what has happened is my land was acquired by the SGDA for development of a township in way back in 2004 and 2005. The scheme of the acquisition was they will give me a fair compensation along with a developed plot under rehabilitated scheme. Though the compensation was paid to me, but the developed plot was not yet allotted to me. Milords, kindly comes to page number 30. This was a interdepartmental communication written by the Chief Executive Officer of the Siliguri Jalpaiguri Development Authority to the Collector Darjeeling.
Is 30.
Page number 30. To the collector, request for verification of awarded list. Reference LA case number such and such. Sir, in reference to the above, I would like to inform you that 0.09 plus 0.09 equals to 0.18 acre of land in plot number 308 of Moza Kavakhali was acquired by wide LA case number such and such, and award was declared by number such and such, dated 24/5/2005 in the name of Sri Sajal Roy and Srimati Pramila Roy. Initially, Brojen Roy, now deceased, was the original owner of the land by deed number such and such for 0.33 acre of land. After death of Brojen Roy, a part of land 0.09 acre was recorded in the name of Pramila Roy, wife, and another part 0.09 acre in the name of Sajal Roy's son. As Brojen Roy sold 0.149 acre to Srimati Ranu Dev, wife of Sri Ashutosh Dev, by deed number such and such. Sri Sajal Roy received compensation from the collector for 0.09 acre of land, and his name was included in the rehab package in 3 kata category C55. But later it is seen that Srimati Pramila Roy has also got compensation for 0.09 acre of land for the same plot. Also, it was informed by Sri Samir Chakravarti and Sri Mati Sati Chakravarti that 0.05 land was acre was purchased in the same plot and submitted ROR. Another person named Sisir Biswas and Bani Biswas are also featured in ROR having 0.05 acre of land in the same plot. Thus, total land, the total R of Sajal Roy and Pramila Roy comes to 0.08 acre in that within brackets 0.04 acre each in the same plot 308. Under these circumstances, further process of allotment could not be done due to the above discrepancy. Though Sri Sajal Roy was allotted 3 kata plot, hence you are requested for verification of the entire issue, since Sajal Roy has intimated that he would refund the amount awarded to his mother's name. So, Millets, in furtherance to this, I have already refunded the amount to the private respondents. Millets, actually happened is there was initially 33 decimal of land. 15 decimal of land was sold to one Ranu Dev. It comes after deducting, it comes to
18 acre, 0.18 acre. Thereafter, 5 was sold to this private respondents,
Total land was 36,
33
33.
decimal. Thereafter, it was sold 15 decimal to Ranude. It comes to 18. Thereafter, it was sold 5 to private respondents. After deducting that, it comes to 0.08. So my prayer number C, my lord kindly comes to prayer number D. What I am asking for is issue an appropriate writs, orders or directions declaring that non-mutation or discrepancies in the record of rights cannot be a lawful ground for withholding delivery of possession of rehabilitated land when entitlement flows from the acquisition proceeding and registered documents. There was registered documents, and they are withholding my developed plots of land.
Okay. So what is the discrepancy has been removed? In para 3, this has been stated.
Para 3.
Under these circumstances, further process of
It has not yet been removed. It is an interdepartmental communication. Till date, my land has not been given to me. And I had made a representation. And in between, the private respondent had already filed a writ application and they have withdrawn.
The land was not in the name of Sajol Roy. It was in the name of his mother.
Mother died and I am the sole person to inherit.
The compensation which has been paid in respect of 5 acres.
5 acres.
0.5 acres. Now it is found that it is you are entitled to 0.4 acres.
4 acres. In respect of that,
what will happen to the 1 acre you have received?
That compensation has been refunded to the private respondents because they didn't apply for a mutation before the authorities at any point of time. Their compensation was received by me. Thereafter, Millers, I have already refunded. I have annexed the bank statements. Millers kindly comes to page number 61. This was the amount 65,000. They are returned to Sati Chakrabarti. This is the private respondent. Thereafter, at page number 62, again the amount of 65,000 was refunded to Sisir Kumar Biswas. So the extra money which I have received as a compensation, that has already been refunded to the private respondents. So what I am praying is, since the money has already been refunded to the private respondents, they have no grievance and they are withholding my land.
Is 65,625 has been assessed by which authority?
By the acquiring authority.
Where is it?
You must kindly give me a liberty to bring on record by way of supplementary affidavit. It was there.
Any report was filed in the earlier writ petition? WPF 1441 of 2020.
Yes, my lords, that was filed by the private respondents. That has been withdrawn by the private respondents as I have already made the payment to them. Even if my lord kindly directs the authorities to decide the matter in calling upon the private respondents and me, because that my rights are flowing from the registered deeds. Just because of non-recording of a ROR cannot be a ground for withholding the land.
Non-recording of the ROR, how do you get the compensation without there being a recording in the ROR?
Lords, their share was non-recorded by, they didn't apply for. And in excess of their compensation, which was received by me, that I have already refunded. And this is the admitted fact that the developed plot has already been allotted
For
to
the
me.
state. You are for the state.
My instruction, my lord, the entire plot is now recorded in the name of the SGDS.
Correct.
Jalpaiguri Development Authority. And if your lordship kindly comes to page 70 of the writ petition, The page 70 of the writ petition, my lord, that is their representation. That is also pending, my lord, before the Siliguri Jalpaiguri Development Authority.
Correct.
And the prayer, my lord, handing over the plot, that decision, my lord, has to be taken by the Siliguri Jalpaiguri Development Authority.
In consonance with LA.
Yeah, Mr.
Special
Mukherjee.
LA.
Yes.
Yes.
Now, my lord, the petitioners, my lord, received the compensation in respect of the land which they already sold to other parties. Now, they enjoyed this substantial amount, my lord, for a considerable span of time. They did not have any objection or did not raise any issue that we have received an extra amount which we are not entitled to. When the private respondent, my lord, filed a writ petition before this honorable court seeking their compensation, then, my lord, they refunded the amount direct to the private respondent instead of refunding the amount to the authority. Now, today, the question is, my lord, admittedly, my lord, they have, my lord, the quantum is 0.08 acre of land which was acquired. Now, they have made a representation, and, my lord, that is, your lordship will find at page 70. Now, your lordship, my lord, can refer this issue to the chief executive officer, my lord, for necessary consideration, or, my lord, I can file an affidavit, my lord, disclosing this fact, my lord, that what amount they have received initially, and how, my lord, my lord, refunded this amount to the private respondents, my lord, when they filed a writ petition. And today, my lord, they are seeking, my lord, a land under the rehabilitation scheme. Now, they are the entitlement is 2 katas of land, my lord, which I was told by the law officer, and it can be decided, my lord, if your lordship direct the chief executive officer to consider the representation, which is at page 70, my lord.
Lord, kindly comes to page 31.
My lord, I think that would suffice, my lord.
They have already admitted under these circumstances further process of allotment could not be done due to the above discrepancy. Though Sajal Roy was allotted 3 katas of plot, hence you were requested for verification of the entire issue since Sajal Roy has intimated that he would refund the amount
You will
awarded
file
to his mother.
supplementary affidavit or have it decided by the
Decided by
authority?
the CEO.
Yes, my lord.
In consonance
My
with
lord, they are not entitled
that
to
respondent
nothing.
number, let them decide, my lord.
Let the
This should
chief
be
executive
delegated
officer
to the CEO
take the decision, my lord.
and special land acquisition of.
That he will decide with whom to consult or not.
This is,
My lord, they are
what is
not
his rank?
entitled to
My lord?
Respondent number 5, my lord.
Respondent number 5, my lord.
Petitioner, seeks for, by the present writ petition, petitioner seeks for handing over physical possession of a rehabilitated developed plot of land measuring 3 katas within bracket category C55 allotted to the petitioner under the rehabilitation scheme pursuant to land acquisition in LA case number 14/4 of 2004-2005 in a time bound manner. The petitioner contains that "15 acres were transferred."
Yes, 0.15 acres to one Ranudev and thereafter 0.05 plus 0.05 to private respondents. In total, 0.10.
Contains that an area of land measuring 0.33 acres was recorded in the name of Surbala Singh in LR Khatiyan number 415, plot number 308. Matigada, this is?
Matigada.
Matigada.
Yes.
The land pertains to Mauza Kawakhali, jail number 75.
Mauja Dhamakhali.
Kawakhali.
Kawakhali.
Zale number 75 within bracket 98.
An area of land measuring 0.15 acres of land was
Lords, I made a table at page 7 for ease of my lordship. At page 7.
was transferred to one Ranu, Srimati Ranu Dev.
Unauthorized acting, sir.
These 5 acres were transferred to Ranu Dev to Shishir Kumar Vishwas.
No, my lord. Thereafter, Brojen Rai himself transferred to Sisir Biswas and Bani Biswas 0.05 acres.
Oh, yes. So all the sale deeds have been executed by Brojen
my
Roy.
lord. That has already been annexed also.
Brojen Roy,
Yes.
predecessor in interest of the petitioner.
Petitioner.
Okay. কি বললাম? By the erstwhile owner Brojen Roy. Stop. 0.5 acres of, land measuring 0.5 acres was transferred to Shishir Kumar Biswas and Srimati Bani Biswas, and land measuring 0.5 acres were transferred to Somit Chakraborty and Srimati Soti Chakraborty by late Brojen Roy. But the land were not mutated. Due to erroneous mutation, wrong inclusions were made in the name of Srimati Promila Roy and
The petitioner.
the petitioner Sajol Roy. The revenue records showed excess of 0.10 acres, showed SHOWED, 0.10 acres in the name of the PT. And Promila is mother.
Mother has already left for heavenly abode. Now I am
Mother.
the only sole person.
A
to
writ
it.
petition was filed by the private respondents being WPA 1451 of 2024. And during hearing of such writ petition, such error was detected.
We'll have two writ petitions were there. 1441 and 1451.
1451. 1441 and 1451. Both of 2024.
2024.
Both the writ petitions were withdrawn.
Withdrawn.
Both the writ petitions were withdrawn since the petitioner transferred the excess compensation received in favor of the private respondents. Mr. Swansol, learned advocate for the petitioner, submits that despite transfer of the excess amount of compensation as per the scheme, the plot measuring 3 katas, category C55, has not been handed over to the petitioner. On 18th August 20, Annexure P5 is, what is the date? 2025.
Annexure
The
P5.
petitioner made a
18/8/2020.
representation before the Chief Executive Officer, Siliguri Jalpaiguri Development Authority, for taking necessary for redressal of his grievance. However, no steps have been taken, hence this writ petition. He submits that the matter be relegated to the authority for taking a decision in view of the representation of the petitioner. Arjun Roy Mukherjee, learned advocate, appearing for the SJDA, submits that in the event the matter is relegated to the authority, it will take a decision in accordance with law. Mr. Kunalji Bhattacharya, learned advocate, you are what?
Is it, let go instruction.
Oh. Kunal Bhattacharya, learned additional government pleader, leaves the matter to the discretion of the court. In view of the submissions advanced.
One submission of mine that now the entire plot is with the SJDA. And since, my lord, the petitioner has prayed for
The SJDA is the appropriate authority to decide.
the prayer of the petitioner.
One small indulgence. My lord, prayer D may be called out. Otherwise, they will again
D?
No.
prayer D.
Today lordship is not deciding on the prayers, my lord.
Non-mutation or discrepancy in the record of rights cannot be a lawful ground for withholding because already it flows from the registered deeds.
Today, my lord is directing the
I will
respondent
place the
number.
registered deeds.
My
They
lord
can
is
decide upon my deeds.
lordship is directing the respondent number 5 to consider the
Otherwise, there will be
representation.
another round of litigation, my lords.
Well, how?
If we
When
are
I started, I asked you, say that yes, representation be
Yes.
said, you said
my
yes.
lords.
Now, again, if this has to be, then you file your supplementary affidavit, call for affidavit from
No,
the
my
other
lords,
side.
we'll let them decide.
It is your choice, you have filed, now you say. 18th August, chief, what is the respondent, which respondent?
Five.
Take a decision in respect with of the in view of the above. Respondent number 5, Chief Executive Officer, Siliguri SJDA, is directed to take a decision in respect of the representation of the petitioner dated 18th August 2025, annexure P5, and dispose of the same in accordance with law by passing a reasoned order within a period of 8 weeks upon notice to the petitioner as well as all interested parties within a period of 8 weeks from date of communication of this order.
Grateful. Grateful, man.
Yes.
Yes, lordship, I honor the lordship. Sir, can it be taken up tomorrow? I've just received the instruction, my lord. This is regarding compassionate appointment.
Not.
Grateful, my lord. Calcutta, पढ़ लूंगा ना एक बार.
I beg to appear on behalf of the petitioner, my lord.
What
My lord, the CPF to GPF, my lord. Petitioner mother was assistant teacher, my lord, appointed in the year 1966, retired in the year 2005. Initially, my lord, the mother of the petitioner under the CPF scheme was not considered. My lord, thereafter the petitioner's mother received gratuity by PPO number 2265 in the year 2007, annexure P2, my lord. Thereafter, exercised the mother of the petitioner was an assistant teacher. My lord, mother expired, son is now paying. My lord, I am covered by this judgment, my lord, of Justice Rajapashu Chaudhary, of Justice Amrita Sinha, my lord, where the son can apply for the area pension, my lord.
Area pension, first he has to get the pension, he is entitled to get pension.
My lord, I am claiming, my lord.
So there are two aspects. One is that the mother was getting pension, the son claims area pension. Mother was not getting pension, never
Mother
availed of.
was receiving pension, my lord.
Where is the
Already
area?
settled the pension, your
How
lordship,
can
on
he
the
be?
4th
How
March.
can he be granted the pension? Is he entitled? Is a disabled person? The husband can claim.
Husband also expired, my lord.
Husband can claim the pension of the wife. How the son not being disabled, or what is the ground for
My
claiming?
lord,
pension?
I am supported by this judgment, my lord. Kindly have a look.
Show me the rule that the son will be.
You have instructions on this?
No, sir.
Instruction is, instruction is.
Then Milord, I am praying for not to.
Instructions are.
Your Lordship, this is for the revised pay scale. Kindly accommodate some time, Your Lordship, for instruction. Because
Primary or secondary?
Milord, higher secondary.
secondary,
Secondary.
Yes, Milord.
Get instructions from. আচ্ছা এটার একটা ডেভেলপমেন্ট করাবেন আমি থাকবো এটা আপনাদের সাথে।
Milord, I am praying for area pension from the date of retirement to the date of refunding, Milord, the area pension, Milord. Because I have returned my pension with interest. Thereafter, fresh PPO was issued in 2015, Milord.
Ashish is the husband.
Milord,
Ashish is husband. Ashish Toru
Ashish Toru is the son, Milord. Ashish Toru, Acharji.
and Ashish.
Ashish Toru is the husband. Ashutosh Acharji is the husband. And Milord, Kanunbala Devi was the assistant teacher. That is the mother of the petitioner. There, two sons are there, Milord. This is the younger son. One is Ashish Toru, one is Ashish Toru. Milord, NOC was given by the elder son because he resides at Delhi. He doesn't have any objection if the area pension was received by the younger son.
Find out the
Annexure P8, Milord.
by the present writ petition, the petitioner.
Milord, this is the order passed by Justice Amita Sinha.
By the
Milord,
present
on
writ
similar
petition.
grounds, Milord.
Affidavit of service.
Affidavit of service, Milord. I have served, Milord.
Ask them to come back tomorrow. India is good.
yes.
And जब वो बोलेगा ना when sending बोलिए जो let me speak get the number and let me speak.
Judgment.
Judgment teacher.
Just ready. Or তোমরা কোনো রিপ্রেজেন্টেশন করেছিল বিয়ের কাছে বাকি যারা চাইছো করে দিলে পারতো
Affidavit of service. Petitioner.
ওরাই তো করবে
By the
তোমার
present writ petition, the petitioner seeks for
আর ওটাকে আনসেটেল করবো ধরো
sanction of pension in favor of the mother of the petitioner from the date following the date of her retirement, that is 31st October 2005, and release the area pension
রেফারেন্সটা দিও না
from 1st November 2002 to 12th August
এই আমাকে
2014.
লিখ
Done advocate representing state seeks to file a report. Let such an advocate for the petitioner submits that the petitioner, being the son of the deceased teacher, is entitled to get arrears of pension. An advocate for the state respondent seeks to file the report. To buttress his contention is Suranjan Das versus State of West Bengal, WPA 2503 of 2025. Let such report be filed within a period of 1 week. Exception, if any, be filed within a week thereof. Advance copy be served. Upon expiry of the parties are granted liberty to mention after expiry of the aforesaid mention period. Next.
Led by Mr. Sujit Kole.
I am for the respondent with Mr. Ronit, but not kindly excuse me for online. I am on. Now on last.
Where is the report? No, report. Where is the report? Report. Yes, give her a copy.
Please disable. My lord, kindly see the
What is
report.
her age?
My lord, kindly see the report.
Yes.
My lord, it's a compassionate appointment. Your lordships kindly consider it is not the matter of right. Now, my lord, it's under the scheme. Now, my lord, the scheme says a spouse for 40 years and son and daughter is 30 years. Now, my lord, the physically disabled persons, permanently physically disabled, then 40 years. Now, my lord, admittedly, when my lord defense client is applied, his age is 40 years, 6 months. So therefore, my lord, under the scheme, he is not, his case does not belong to the zone of consideration. That was exactly our rejection letter also. That is at page 41.
Where is that policy?
The policy under which manner they have rejected my application, that is manner as per their report by policy 2010 issued by circular number 2024-2010. This policy has not been annexed here. What it has been stated in the policy, lordship, that they give me the time so that I can find the exception, because lordship, that 40 years age bar is not applicable in case of the group D employees, lordship. Maybe it is in the case of the appointment in respect of the higher bank, but not in case of the group D employee.
Kindly come on.
Report.
My lordship, my lordship is saying that policy and everything.
Class 8 pass.
Your lordship kindly.
So she is not expecting
Your
for a
lordship kindly
post.
give
It
me.
is, my lord.
Report filed
All
by.
right, my lord. We shall come with an affidavit, detailed affidavit. If my lordship is so happy, and it's all the documents and including the policy. Policy clearly says, my lord, is not under the zone of consideration.
You will file affidavit.
If your lordship so desire, we can. Annexing all the documents, because my
No,
lordship
whatever.
is.
No, what was the direction?
No, direction is to file a report.
Direction was to file a report.
We have filed a report.
For my lord to file the exception, my lord, independent opposition lead like my lord, unnecessarily the matter will be delayed, lordship.
That's at your lordship. Because
The report
compensation
filed by the WBACDCL is taken on record. Copy served. Ms. Suman Sehanobis, learned advocate for the petitioner, seeks to find exception to the report. Let such exception be filed within a week. Parties are at liberty to mention after expiry of such period. Next.
Yes, Lordship. I'm for this state, Lordship.
Okay. I will add that. And the response number here and when the petitioner and his wife
with a particular property of 65 bighas of land to be purchased, which was executed on 20th of January 2021. Subsequently, that agreement, the part payment was made. Subsequently, the rest of the amount was paid to the owner, and thereafter, upon full payment of consideration on 22nd of December 2021, a deed of sale was executed on 22nd of December 2021 by and between the parties, and which was before the respondent before the respondent number 4 and respondent number 4, but and that and registration process was going on in a particular miscase application. When that registration was going on, the respondent number 12 has passed a general direction that registration cannot be held because there is an administrative embargo by the respondent number 5. Therefore, the registration is still deferred. Now, in this particular juncture, what happened that the property was in possession of the petitioner and he was cultivating the land. Now, what happened on 17th of December 2025, an attempt of disposition was made against the petitioner by other person. Upon inquiry, the petitioner came to know that the same plot of land was sold and registered by the same seller, that is respondent number 12, through his attorney by 11 respondent number 11, and before the same registration officer at office at Calcutta. Despite the fact that there was still that administrative embargo, but somehow they have managed to get registration, and register has been done. And immediately thereafter, the petitioner applied for this impugned deed of sale and it challenged it. And thereafter, they have invoked the provision that approach to the respondent number 5, who is the original authority who has passed the embargo. Due to your embargo, my registration is deferred, whereas the same property is being allowed to register despite operation of the embargo. That particular authority, respondent number 5, keep silent, and which compel the petitioner to come before your lordship. Now, this is the whole scenario. I have challenged the particular action of the respondent number 5, where during the continuation of that embargo, kindly see, lordship, that embargo is at page 59. So got it? Yes. The undersigned is to refer the above and to request him to direct all the registering officer under his control not to register any such property until further communication, and received from this end, and also to send information of such property, if found, if any, directly to the applicant with an intimation to this directorate. So this was the embargo. That apart, lordship, kindly see at page 39 of my application. where there is the same authority under the caption heading that the prayer for blocking of sale or transfer of the landed property belongs to the alleged director so-and-so financial establishment named so-and-so that has been done. So now that embargo was put on, that was operative. Kindly see. The third paragraph, this directorate is trying to best to attach the movable and immovable assets either in the name of the fraud financial company, in the name of the of its official. During investigation, it could be learned that the official of the company have purchased landed property in the jurisdiction of West Bengal, especially North Bengal, for which I request you to kindly verify of this aspect and to as to the landed property have already been registered either in the name of the fraudulent financial company and in the name of the official, and also an order may kindly be passed for freezing of the property and to look into that property shall not be transferred or otherwise dealt with except prior to permission of the undersigned. This direction was passed on 10th of December 2021. Only because citing this particular embargo, my registration was withheld. I was not aggrieved of. I approached to the authority. Now the registering authority kindly appreciate one thing, that see kindly page 80 of my application.
The property belonged to the company. We are
That the directors of the company
weird
who are under scanner, yes, who are under scanner of investigation. So since my payment has already been paid, registration was withheld due to the investigational embargo. I was not initially aggrieved of, because I contemplated that the moment embargo will be lifted, my registration will be completed. But that on this particular juncture, the same authority had allowed it, the respondent number 5 allowed it the subsequent deed. Kindly see the deed. That impugned deed is at page
41.
Page 41, exactly. Kindly see the date, 13th of October 2025.
And that order you have shown,
Worship,
embargo order,
embargo order is page 59. Until further order.
the date of the order is
Date of his order 10th of January 2022.
22. And this has been executed in 25.
Exactly. Despite the operation of the embargo. So I have been treated discriminately. At one hand, my registration is deferred, and on the other hand, same land with a different instrument is being allowed to register without any reason, despite operation of the embargo. Even not only that, the same registering authority kindly appreciate, see at page 80 of my application. The Joint Commissioner of the Revenue District Register Jalpaiguri has requested to the petitioner that to take necessary steps to unblock or deblock for completion of the registration. I approached to the authority, but the authority kept silent. That was that communication was made on 23rd of March 2023. I was not sitting tight. I had attempted.
So this authority you have approached?
Yes.
What is it?
My at page first page 81. The petitioner on his own
Directorate of Economic Offences.
Yes. That I approached on that page. At page 61. I have made all the concerned authority in one arrayed in the parties, so that the lack of coordination was not made. Despite acknowledging this communication, they remain silent.
No. In page 80 says that authority of the Directorate of Economic Offences.
Yes, the Director of Economic Offence has made party. Kindly see.
Lordship, may I intervene? The FIR was lodged in year 2014, Lordship, but subsequently in the year 2020, Director of Economic Offence taken over this matter, Lordship, because the matter is related to the
No,
offence
no.
of the.
Director of
Yes,
Economic Offence has been intimated by.
yes, 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 page 64, kindly see. Copy to 1. Page 64, copy to 1.
Because
then?
Lordship, investigation is now conducted by the respondent number
5.
5, Lordship.
But how this transfer has been made, he says that
Yes, Lordship.
it has been made in favor of respond number.
Respond number, respondent number 11.
11. And who are the other private respondents?
The private respondent, the respondent number 12 is the original owner, and the respondent number 3 is the power of attorney. 13 is the power of attorney holder of the respondent number 12.
And respond number 10?
Respondent number 10,
Pradhan. What is his function?
he is a Gram Panchayat Pradhan. He was intervened unduly.
It's not a. Tapon Sarkar is the person in.
Latest purchaser, purported purchaser.
And Sanjay Kumar Das?
Lordship,
Sanjay.
he is the original owner.
Okay. This Sanjay Kumar Das has executed, or the company directors have executed?
Yes, yes.
Directors have executed.
No, in the impugned deed,
Sanjay Kumar Das has executed.
Sanjay Kumar Das didn't personally execute the deed, but he has given the power of attorney to the respondent number 13, who has executed this impugned deed. Page 43, kindly see.
Does this not belong to the company?
I believe so. Belong to the company.
But if it is a private land in the same plot, it has nothing to do with the Director of Economic Offences. There was blocking of the registration.
Yes.
Since there was a FIR relating to economic offence by
Offence
the
wing.
weird company.
Exactly. So this
Now this was blocked, pending the investigation.
exactly.
Now you say that a piece of land belonging in the same locality, having the same moja and all, this has been transferred in Calcutta,
Calcutta.
executed.
Yes.
Where on
RA
the
Calcutta,
other side,
RA Calcutta.
RA Calcutta.
Yes.
And the petitioner, due to such blocking, could not have the deed
Registered.
executed in his favor.
Yes.
But both the land belong to the
Same,
company.
same.
Company.
Company.
So how the Sanjay Kumar Das is executing by giving a power?
On, as a director?
He's a director.
Yes.
Oh.
Now the issue, Lordship, is that discriminatory treatment is being meted out to me. So I agreed up. I praying initially before your Lordship that the impugned order, impugned deed should not be, does not have any legal impact or of any operation. That interim order is required initially, and my possession may not be disturbed because of this.
You filed your report? How this has been executed?
Yes, Lordship. Lordship, after receiving this free petition, Lordship, we inquired the matter, Lordship. Yes, it's true that one deed has been executed in the year 2025, Lordship, after the embargo, Lordship. But Lordship, on 27th May 2026, we have already wrote a letter to frozen this property, this sale deed, Lordship. So in the meantime, Lordship, actually, investigation is going on, Lordship. Initial charge sheet has already submitted, Lordship. But instruction which I have received, according to that, the department will again file a supplementary charge sheet, Lordship, because what the petitioner is submitting, that the subsequent sale deed was executed after the embargo, Lordship.
You come up with a report regarding the complaint he has made before the concerned authority, including the Deputy Superintendent of Police, alleging that during the blocking of registration, the director has transferred.
Yes, Lordship, it is true. In the report, Lordship, we have got this information, Lordship.
After filing this writ petition, we went inquired about the matter. This is reflecting that one deed has executed by, in the name of the Tapan,
Okay,
Tapan.
what is the steps taken? If there was violation of
On
the,
25th, 2026, we have further submitted a requisition to the additional registrar of assurance, Kolkata, for blocking this sale deed, lordship. Because the first sale deed is the potential produce of the crime of economic offense. Subsequently, after the embargo, lordship, this sale has been sale deed has been executed, lordship. That's why we need to further supplementary charge sheet, lordship. Because in the year 2022, lordship, we have filed one charge sheet, lordship. But after the embargo,
no,
lordship, we have to
what
file
is the
another charge
response
sheet,
of RA Calcutta with regard to blocking of the registered deed of executed in favor of 11? What is the response?
27th May, we have filed the requisition, lordship.
Okay.
So we are waiting for the response, lordship.
Everything report.
Fine, that is 13th October, this was executed.
Yes,
The complaint was lodged on
24th of December 2025, page 61.
But we page 61.
Show me that letter to the RA Calcutta made by the authority concerned.
Lordship.
File a report in the form of affidavit annexing all the documents, the steps taken after the complaint was lodged by the petitioner.
Yes, lordship.
Wait, come up with that report,
Yes,
because he needs to go through that. Because if you are intending to file supplementary charge sheet
Yes, lordship.
of the subsequent event,
Yes, lordship.
in that event, the complaint of the petitioner has to be investigated.
Yes, lordship. It's true, lordship. We are admitting that subsequent register has been executed.
Mr. Where is your affidavit of service? Private petition is taken on record by the present writ petition.
Ashok, may I say one?
The
See, and
petition,
an interim order may be given.
not at this.
देखना था.
Let them come up with a report.
Mark
Submits that. Directing respondent 5 to show rationality and legal justification of manifest ambiguous and evident discriminatory use of impugned embargo on registration of executed deed of sale of the petitioner dated December 2021 under memo number 1226/DEO dated 10th December 2021
है ना?
issued by respondent number 5. Sir, Arnob Saha, learned advocate for the petitioner, submits that the petitioner entered into an agreement for sale on which date this agreement for sale was?
On agreement for sale on 20th of January 2021.
2021 in respect of the land
65 biga.
65 bigas comprised within para 6
Para 6, yes.
comprised within Mauja Chowk, Maulani, jail number 93, seat number 1, RSN error plot number 499. This is police station, Malbajar, district Jalpaiguri. However,
section
the
5, section 16.
process of registration has been deferred by the Office of District Registrar, respondent number 3, Jalpaiguri, owing to an apparent embargo put by respondent number 2 pursuant to a general direction made by Deputy Superintendent of Police, Directorate of Economic Offences, Government of West Bengal, respondent number 5 on 10th December 2021. In view of such embargo, the petitioner was waiting for lifting of the embargo so that he can execute. He could have the deed of conveyance executed in his favor. In the meantime, it has come to the knowledge of the petitioner that on 17th December 2025, a deed of conveyance has been executed in favor of respondent number 11, Tapun Sarkar, by one of the directors. One of the directors or
But yes, one of the directors.
one of the directors, namely Sanjoy Kumar Das, respondent number 12,
Via power of attorney.
to a power of attorney executed in favor of respondent number 13 in the month of October 2025.
Sorry, Lordship, in favor of respondent number 11. Power of attorney holder is 13.
No.
Attorney holder is 13.
Yes.
Owner is 12. 11 is purchaser.
That is what is the
Yes.
The petitioner
Power of attorney holder.
lodged
Well, this-
a complaint with the
13. Owner.
with the where is that?
পাওয়ার অফ অ্যাটর্নি হোল্ডারের নাম দিয়ে রেজিস্ট্রি করেছে বলে রেজিস্টার বুঝতে পারে।
With the
এটাই হয়েছে, কোম্পানির নাম দিয়ে করেনি, কিছু তো একটা হয়েছে।
Joint Commissioner of Revenue and District Registrar Jalpaiguri. And in response to the same, on 23rd
वही
March
हम सोच रहे थे
2023,
कि
the petitioner
इसको तो
was
अपनी का
informed
instruction इस तरीके से
to
आया तो क्या
approach
करेंगे?
the appropriate authority for redressal of his grievance, namely Directorate of Economic Offences. On 24th December 2025, petitioner made a complaint before several authorities and a copy was forwarded to Deputy Superintendent of Police, Directorate of Economic Offences. Date and complainant. Ms. Supriya Singh, learned advocate appearing for the state respondents, submits that the complaint of the petitioner has been received by the investigating authority and the investigation is still going on. The response has been sought for from we registrar, ওইটা বললাম আরে ক্যালকাটা, ওটা বলে দেবেন তো তখন সরকারের যে রেজিস্ট্রেশন হয়েছে ওটা আরে ক্যালকাটা. The response has been sought for from আরে ক্যালকাটা.
Yes,
আরে ক্যালকাটা, which has not been received.
are they called?
She seeks
They
to
are called.
file report in the form of affidavit. If such report in the form of affidavit, they file within a period of 2 weeks, advance copy be served, 1 week to file exception if any.
Lordship, one indulgence, Lordship, the point of maintainability should be open, Lordship, because in the Act, section 90.
If the file report she submits that
Section 90,
the writ petition is not maintainable. 3 weeks liberty granted to mention after expiry of the period. The point of maintenance is kept open and shall be decided.
So report will file on through affidavit. They will file their affidavit. Lordship, kindly mention it.
And the affidavit part.
Grateful. Madam for the.
What is this?
But the fact of the matter is that, my lord, the
What is
petitioner,
that affidavit?
I don't have the instructions, but one thing, subject to, you will also submit. At page 24 is the representation which is pending before the authorities. Now, the petitioner before your lordship is praying for provisional pension. Now, if that can be sent for consideration within a short period of time, maybe that will, my lord, help the
Yes.
petitioner.
yes, ma'am.
Page number?
Page number 24, my lord.
Not 24, my lord. It's 55.
Sorry, sir.
55. This is the last page before the back sheet.
P5.
P5.
24 উপরে ছিল
Thank you.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for disbursement of provisional pension in terms of Rule 10(2) of West Bengal. এটা পুরোটা হচ্ছে West Bengal DCRB rules 1971. The petitioner contains that the petitioner was appointed as a job assistant and joined the government service on 20th July 1999 at Gitaldoho 1 Gram Panchayat under Dinhata 1 Development Block, District Kuchbihar, and discharged his functions diligently. What is the allegation against you in criminal proceeding?
Defalcation of funds, my lord.
13. This is the amount.
was started in the year 2010. I have managed to all the
Page 4, if your lordship comes to the writ petition.
the trial has been procrastinated. Not a single witness has turned up.
Paragraph 4,
There was a objection.
page 3.
By the trial court to bring the record to the district magistrate. No documentary evidence has been placed to the trial. I managed to all the up to date all the sheets.
What is the date of initiation of the 2010?
Yes, sir.
Yes, my lord.
DCRB rules, my lord, Rule 10 says, my lord, despite, my lord, pendency of, my lord, any judicial or disciplinary proceedings, my lord, provisional pension, my lord, may be allowed. That is.
And what about the moral turpitude?
My lord, may I hand over, my lord? Rule 10 and 14.
W. This year.
10-2, ma'am.
10(2).
Yes.
Any departmental proceedings has been initiated?
No departmental. Even, my lord, after initiation of the criminal proceedings in 2016, the petitioner got promoted. My lord,
In 16?
in 2016, my lord. Page 53, my lord, kindly have a look. That is the order passed by the, my lord, the competent authority. There's a list of the, my lord, the promotees. Serial number 3, my lord, indicates the petitioner's name.
না না 2014 short is 13. He's 13.
Serial number 13.
13.
Ashok. During his service tenure, the petitioner was implicated in a criminal proceedings being Dinhata Police Station case number 453 of 2010 under section 409 of the Indian Penal Code, which is pending before the learned special judge at Kuch Bihar. The petitioner was arrested on which day?
Well, he was endorsed on bail by partial order passed by the
No, this is of anticipatory bail or?
not bail.
So the student 29th of December 2016, my lord, he was granted.
Page 23, my lord, order.
Achha. The petitioner was granted bail by the Honorable Court in CRM 7623 of 2011. Or date to the The petitioner was also thereafter the petitioner was also promoted to the post of executive assistant and posted at Jalpaiguri 1 Gram Panchayat. Video office notice dated 29 December 2016. The petitioner superannuated from service on 31st January 2025 upon attaining the age of retirement. However, no provisional pension has been released in his favor. On 23rd February 2026, the petitioner made a representation before the authority concerned. It will be which authority?
District magistrate, DPRDO.
The district magistrate.
The district magistrate and collector Kuch Bihar respond number respondent 2 seeking for sanction of provisional pension. However, the same has not been considered, hence this writ petition. Mr. So-and-so, learned advocate, appearing for the petitioner, seeks that the matter be relegated to the submits that the petitioner under Rule 10(2) of the DCRB Rules 1971 is entitled to provisional pension in the event of pendency of the judicial proceedings. He seeks that the matter be relegated to the appropriate authority for taking a decision on the representation of the petitioner dated 23rd February 2026. Para. Mr. Kunaljit Bhattacharya, learned additional government pleader, also submits that the matter be relegated to the appropriate authority to decide in accordance with law. This respondent number 2 is directed to decide, take a decision in respect of the representation of the petitioner dated 23rd February 2020 by 26. Annexure P5 and dispose of the same by passing a reason order in accordance with law upon notice to the petitioner. The reasoned order shall be communicated within a period of 6 weeks from date of communication of this order.
It's found, my lord, in the reasoned order that the petitioner is entitled for provisional pension, my lord. Consequential step may be taken.
That is as per law, my lord has been pleased to record.
In accordance with law, they will take steps. It is made clear that this court has not gone into the merit of the writ petition.
Just one thing, there was a direction upon the state to file a report in Tamil Nadu. There is no order, you have to give a notice. You have to only come to ask for a notice. That is a matter will kindly. Thereafter, immediate order will be passed. Yes, it is part of my report at page 6. This was the document my knowledge for the particular matter was referring to, and the kindly see, it is addressed to the application. The confusion of in main matter because the application is no longer. Having said that, my lord, this is has been given before that, my lord, inquiry was held, and at page 4, my lord, is the earlier one, earlier notice, which was again given to the petitioner in the month of April. Only see page 4 of the report. Exhibit number 2, my lord, is the petition. Page number 7 is the relevant. In the inquiry considered them, they said that not my interest of considering the CWD one. You are part of it. So whatever I will tell you, only one instruction from the very well, my lord. This petitioner, my lord, just to give the instruction that the enclosing part is a part of the shop. You demolish by them, and it doesn't solve the problem. Thank you. Let me come back to the instruction. It's not
Containing identical subsequent events as that of the cat. Will also be on record. I have my.
My lord, we have been served with the copies, my lord.
Affidavit as well as the cat. They will not mind if your logic can kindly consider it for 1 minute, otherwise they'll come back definitely tomorrow morning. Our prayer is innocuous today. Ground first and second floor were interconnected by a small staircase and an internal baby lift, pneumatic lift. They are now demolished in terms of an action taken by the SMC last Saturday. This was certain pending petitions, but there was no interim order preventing the demolitions. So they are now demolished. Their allegation was that these required prior permission from them, which I had not taken. Whether they are temporary or otherwise are matters of merits in the petitions, which have now largely been rendered academic. Now that they have demolished it, now what I am humbly beseeching for your lordships is, in my representation, I am the franchisee, which is carrying on the activity. What I am beseeching is that I make an application for them. They will inspect the premises and suggest a suitable place where they can give me pre-installation permission for the internal staircase and the lift. That's all. Second, first they have demolished it all of a sudden. At that place, there is now no vertical connectivity at all in my store. My store is therefore almost at the verge of closing. It's a running business. So I was humbly beseeching that instead of that RCC staircase which they have demolished, intra-store staircase, if I be permitted to put in place a small wooden staircase to serve the purpose for the time being without prejudice. That the wooden staircase would be not protected by plywood, wood, copper, hard wood, which is ordinarily used for internal staircases. I'm not going to compromise on safety or quality. I assure your lordship can take my undertaking that it will be of the highest quality, no question of any casualty. It's just for intra-store mobility. Intra-store mobility from ground to first to second. If I can be allowed, use this infrastructure for the time being until they revert on the basis of my application. I'm ready to apply tomorrow. I'll apply tomorrow. Let them come with instructions or let them make an inspection. Then let them tell me where they want me to install the appropriate staircase and the internal they will fill that. They have a policy in force where they allow existing buildings to be refurbished with internal staircases and lifts. That policy I have annexed. That's not 19 December 2025. It's a policy of the corporation. So what I am seeking would not be dehorse their policy, it will be in tune with their policy. The only difficulty was that I had put up those structures when I had made the store without prior permission. So now the structures have gone. Now I am applying for prior permission. My lords, notices were issued to me. I have contested and the writ petitions were pending. According to me, these two structures are temporary in nature and cannot form the subject matter of demolition proceedings. Be that as it may, they have now been demolished. Prudence dictates and my business interests dictate that I do not now really fight over those issues because otherwise my business will be hampered. So I am ready, Lord. Now I am rolling down the red carpet as far as they are concerned. I am making a pre-installation application. They will confirm to your lordship that they have demolished it last Saturday.
Take instruction, come back tomorrow.
My lord, my lord, may I submit, my lord? My lord, till date, there has been no application made before the Jalpaiguri Municipal Corporation, my lord.
I make an application.
Let them make an application before the authorities. Let the authorities are the appropriate authority to consider the application according to the policies. If the authorities consider it to be fit enough, then the authorities will pass a direction to that extent. And my lord, the installation can be done, my lord.
But how long you will take to that?
My lord frames a time frame. My lord puts a time frame that
Tomorrow.
this application to be.
The application come up tomorrow.
The can application.
Yes.
Yes.
And they will, in the meantime, they will take necessary instruction. Let them come back in the morning tomorrow. We'll take it.
Yes.
Deeply.
So we keep not slide up on the board.
It will be under application heading. I suppose there is one application which has already been scheduled. Thereafter, I'll take it. Before the hearing matter, the applications will be taken.
Keep the blessing.
Deeply.
How are you, Mr. Banerjee?
It's a pleasure to appear to you, Lord. Thank you.
বন্ধ করে দিচ্ছি বন্ধ করে দিচ্ছি